All right, let's talk about something called misrepresentation. It's a huge deal in contract law. We're going to dive into what happens when a statement that gets you to sign on the dotted line turns out to be false, and more importantly, what the law actually does about it. I mean, we've all been there, haven't we? You're right on the edge of making a decision, about to sign a contract or shake on a deal, and one key piece of information just clicks. It seals the deal for you. But what happens when that fact turns out to be, well, not a fact at all?
Well, in the legal world, that deal-making, and sometimes deal-breaking statement has a very specific name. It's called a misrepresentation, and understanding this term can be the key to unwinding a whole contract that was built on a shaky foundation.
So, not every little white lie is going to tear up a legal agreement. There's a pretty high bar. We're going to look at the specific criteria that turn a simple false statement into something the law can actually sink its teeth into. Okay, here's the official definition. For a misrepresentation to be actionable, and that's just a fancy way of saying you can actually sue over it, it has to be a false statement about a material fact that directly induced you or convinced you to enter the contract. Every part of that sentence is important. To figure out if a claim of misrepresentation will actually hold up in court, there's a simple but really powerful test. You can think of it like a recipe. You absolutely need all three ingredients, or the whole thing falls apart. And here they are. First, there has to be a statement of a material fact, something important, not just some trivial detail. Second, that statement has to be flat out untrue. And third, and this is the real kicker, that false statement has to be the reason, or at least a major reason, that you agreed to the deal in the first place. You need all three, like three legs on a stool. Now, here's where it gets really interesting, because this is where all the nuance is. There are actually times when someone can say something that isn't true, but it doesn't legally count as misrepresentation. The law gets very specific here.
The biggest line in the sand is drawn between a statement of fact and a statement of opinion. A fact is something you can verify. This car gets 30 miles to the gallon. An opinion is just someone's belief. This is the best-looking car on the road. Generally speaking, an opinion, even if you think it's a bad one, can't be the basis for a misrepresentation claim. There's a classic case that illustrates this perfectly, Bissett v. Wilkinson. A seller was selling some land and said he thought it could probably support about 2,000 sheep. Well, turns out it couldn't. But the court ruled it wasn't misrepresentation. Why? Because the seller had never actually farmed sheep there himself. He had no special expertise. It was just an honest guess, an opinion, not a hard statement of fact. Okay, here's another subtle but absolutely critical difference. If someone says, I plan to renovate this building next year, that's usually just speculation about the future. But if they say that while knowing full well they have no intention of renovating just to get you to sign a lease, well, now they're not speculating about the future. They're lying about their present state of mind. And that, the law says, is a statement of fact. And this isn't just a theory. It happened in a famous case called Edgington v. Fitzmaurice. Some company directors raised money from investors, telling them it was for expanding the business. But in reality, their secret plan all along was to use the cash to pay off old company debts. The court said, yep, that's an actionable misrepresentation. They deliberately lied about their current intentions. So this brings up a fascinating question, right? If misrepresentation requires a statement, can you get around the whole thing by just keeping your mouth shut? Can silence be a lie? As you can probably guess, it's not quite that simple. You might be surprised to hear this, but the general rule is that silence is not misrepresentation. You typically don't have a legal duty to point out all the flaws in what you're selling. In one case, Keats v. Cadogan, a landlord rented out a house that was in terrible shape but didn't say anything about it. The court said that's okay. He didn't lie, he just stayed quiet. But you knew there had to be a but, right? There are exceptions. There are two really big exceptions. First, if you say something that's true, but then circumstances change and it becomes false before the deal is signed, you now have a duty to speak up and correct it. The other big one is for contracts that require utmost good faith. The classic example is an insurance contract. You have to disclose all the relevant facts about your health or your driving record because the insurance company has no other way of possibly knowing. In those cases, silence can absolutely be a misrepresentation. Okay, so we've figured out what counts as a misrepresentation, but the law goes even deeper than that. It actually categorizes them based on the mindset of the person who made the false statement. You know, was it an honest mistake? Was it a careless one? Or was it a deliberate, calculated lie? Basically, you've got three main flavors here. An innocent misrepresentation is an honest mistake. You truly believed what you were saying was true. Negligent is when you were careless. You didn't have reasonable grounds to believe it was true. And fraudulent is the big one. That's an outright lie. And notice how the outcome changes. The more blameworthy the statement, the harsher the legal remedy. The intent behind the lie really, really matters.
And if you want the gold standard legal definition of fraud, you can't do better than this quote from the landmark case of Dairy v. Peak. The key takeaway here is that fraud isn't just about knowing something is false. It can also be fraud if you say something without actually believing it's true yourself. Or, and this is huge, if you're just completely reckless about whether it's true or not.
So what about that middle ground, negligent misrepresentation? Well, it often comes up when there's a special relationship between the parties. Think about it. A client relying on their accountant, or a borrower relying on their bank. In the case of Hedley Byrne, the court basically said that when an expert gives advice they know someone is going to rely on, they have a legal duty to take reasonable care to make sure it's accurate.
Okay, let's bring all this home. What does this actually mean for you in the real world? Let's put together a quick, practical toolkit you can use the next time you're in a negotiation.
Here are the questions you should always have in the back of your mind. First, is this a hard, verifiable fact, or is it just sales talk and opinion? Second, was the statement really the thing that made you say yes? And finally, try to think about the other person's mindset. Was it an honest mistake? Were they being careless, or were they trying to pull a fast one? Remember, not every fib breaks a contract, but the ones that do can have huge consequences.
So the next time you're about to shake hands or sign a contract, just take a second and ask yourself, what's the one statement that you're truly relying on to make this decision? Is it a provable fact, or is it just a hopeful opinion? Knowing that difference isn't just a good business practice, it's your single best legal protection. Thanks for tuning in.